move in the right direction under your guidance, perhaps something wrong will happen. Please, you present your views.
Thanks. Senior Counsel Advocate Rajendran Nair, RERA Member Mr. Mathew, Mr. Cherian John, Advocate Johnson Gomes, distinguished audience. First of all, I thank the Society of Construction Law Kerala chapter for organizing this seminar, a good initiative, and give me a chance to share our experience and views in this forum for common good. From the discussions so far, it's very clear that an act that was passed and made into a legislation almost 40 years back has still not been made implementable. It's no surprise that nobody has wanted to use it, or there is no pressure from any of the concerned agencies to force the intended users to use it. Things are so far pretty clear. And I use the word victims, sir, because if this seminar was about rape prevention laws, then I represent a gang rape victim. The perpetrators are right from legislative to everyone in between up to judiciary, through either their indifference or maybe lack of interest in performing what they are expected to do for the common cause. Why this act is today thoroughly unimplementable? If you give me 5 minutes to narrate our story, it is easy to come and give a realistic touch to this conversation. Mostly such seminars and conversation end up being academic. We discuss about various laws, various paragraphs, various sections. I will speak as a layman who tried to use that act for our benefit. The only crime we did was we were the first community who insisted on registration under this act. 3 years back, actually, to be honest, we also didn't know about this act. This is an accident. Tritvam, our community, just 6 years old. People started living there from 2016. And in our sales agreement, the builder with all good intentions said, we will help registering the association, Owners Association, and it will be registered under the Kerala Apartment Ownership Act of 1983. We said, fine, you know, like all of us, we signed the sales agreement 30 pages without reading anything. And people who owned maybe another apartment before, like me, I thought every time it is Society Act, no, by this Apartment Ownership Act, no one heard about it. We said, okay, let it go, we'll see. So the size of the complex is about 572 apartments. And almost 80% are sold today, about 20%, about 100% yet to be sold after 6 years of existence. So somewhere in 2020, just 2.5 years back, the builder said, okay, now we have about 300 plus apartments sold. Let's form the association, we'll help. We'll call a general body. The general body was called. It was a good response. And draft bylaw was prepared by the builder and circulated. And bylaw was discussed. The general body with the majority adopted the bylaw. And then elected the management committee, secretary, president, everyone. Then the next step, registration. It was COVID time. And some of the government offices are not functioning or partially functioning. So our builder, in all honesty, they started the registration process by trying to file this declaration as stipulated in the Apartment Ownership Act. Then they came back to us saying that, sorry, we cannot, fulfill what we promised to us for registering your society under Apartment Ownership Act. It is too cumbersome. We together managed to register about 10 declarations. 10 declarations from 10 apartment owners. Builder came back to us and said that, sorry, we can't do anything more than that. It's too cumbersome. Plus COVID, and everyone used to blame on COVID for anything. And we don't have the infrastructure. We don't have the office staff to cover for everyone. So we are dropping the ball here. If you want, we can get you registered under Societies Act. Then we said no. It is mentioned we signed up for getting registered under the Kerala Apartment Ownership Act, and now we discussed it sometime at some length. We also feel that this is a right act. This is an act specifically brought in for managing the condominium or apartment complex properties. Let's go for it. Why tell a lie that we are a charitable society or a literary society? Why tell a lie? We are an apartment complex, and this is an apartment ownership and owners association. Let's go and register under the. How difficult it is? Okay, then they said, oh, that's your baby now. If you want, we can help you registering under the Kerala Societies Act. Or otherwise, you look after yourself. Then we said, okay, thank you. So, Nori, we will take care of ourselves. So, this is a crucial point we made. We told them, thank you, no need. If you're going to register us under Societies Act, we don't need it. We want registration under Kerala Apartment Ownership Act. If you can do it, we'll do it ourselves. Then we started, we got in touch with Advocate Johnson. We started exploring how to do it. We went to the competent authority, Then we went to the High Court, praying High Court's direction, saying that please direct whoever it is to help us with the registration of the association. Finally, High Court issued an order. The government appointed the Deputy Collector, Disaster Management at the Competent Authority for Ernakulam District, and the Competent Authority under the Deputy High Court gave us we call us a registration certificate. Somebody calls just a receipt of what you submitted. A file number saying that this has been received, and so it doesn't clearly still say you are registered as a society or registered as a apartment ownership association under the rules and regulations. And then according to the Act, there should be a separate structure, infrastructure in the sub-registrar's office, separate register to be kept for all these associations or societies registered under this Act. And competent authority is supposed to, we don't know still, who's the ultimate registration authority say that this apartment is registered. So what happened now today? Then in-house we have no issues. We are going ahead with our life as normal as possible. We have now I represent the third management committee. Okay, I was secretary in the last committee also. We have democratic elections. We form management committee. We collect maintenance fees. We take care of the property. We spend the money, account it, audit it, general body. But what happens is, there's a strong section of our own community challenging us. Who are you? Who gave you legitimacy? Just by deputy collector giving you a receipt doesn't make you a legitimate society, registered society. That number you give is the file number, it is not registration number. So even today, we have a fight there. That even when I try to tell something, there are people, including senior legal professionals, asking, who are you? You are not a registered society. Then I'll go back a few months prior. So we went to RERA, saying that please help us. The builder promised to register us under Kerala Apartment Ownership Association 1983. They said they went halfway, they dropped the ball, and then we had to go to the High Court and get an order to direct government to do that. But this builders failed in ordering his promise to help you to complete the registration process. Please direct the builder to do that. RERA heard our plea, got the builder. Couple of months back, we got the order from RERA judgment. I am not using this forum as criticizing or challenging the RERA order, because we formally, as a next step, because we don't agree with or we disagree with RERA order, we have gone to the appellate authority to challenge it. So RERA order said, see, the builder is supposed to help you with formation of the association and registration. He tried, and at some point you said no, we don't need your help. Then builder has done his duty, and we can't find fault with the builder. But in the judgment, the authority didn't look at the context, why and how we ended up saying no to it. We ended up saying no only for builders. Second option is registering us under Society Act, which we said no, clear, accepted. But that doesn't absolve the builder from not honoring his original promise of registering under the Kerala Apartment Ownership Act. Then one of the members in the order went 3 steps further. That member addressed the legality of our association. He said, you have only 10 members because only 10 declarations has been filed. How can you claim that you are an association representing the majority? So at that point, the member ignored the fact that there is a bylaw adopted by a general body majority approval, and democratic elections going on. Management committees and day-to-day businesses being conducted, properties being maintained, money collected, accounted, audited. So that came as a big shock to us. It just happened a couple of months back, saying that from in the RERA order itself, even I don't know whether it is ordered or not, RERA order questioned our legality. Then no wonder, what will happen back home. Everyone started the big, look, we have been telling you, you are illegitimate. Your registration is hollow. On top of that, look what RERA said now. RERA also said that your registration is hollow. Only 10 members in the association. How can you claim that you have the authority to collect the money from us? So there are people who are not paying the maintenance fees just because this grounds. Who are you to ask money from us? But they will enjoy the facility. That's a different thing. If something is not working, they come and complain. But there are people, a good number of people still not paying. So now, why it is so? It is, now we have gone through the law or struggle with it. We know that there are 2 major problems with the Act. One is the definition of the applicability of the law, the famous or infamous section 2. We say that the Act is applicable to a society where the sole owner or all the owners are signed the declaration, registered it. Just think of it. Now, most everyone has touched upon it. We have 572 apartments. Some are to be 20% still to be. But is it possible to gather all 572 people and get the declaration signed and give it for getting the registration process complete? The second thing is the chicken and egg situation. On the one side, the Act said that all the documents submitted, declaration, etc., has to be submitted officially by the Secretary and Management Committee. But how will you have Secretary and Management unless the association is formed? To form the association, you have all the declarations submitted there. So, which comes first? So, as a practitioner, not a practitioner, as someone who wants to use that Act, which is made for us, governing us, what actions needed from our point is, on the ground. Number 2, the Act has to be cleaned up. The inherent contribution has to be cleaned up. Section 2 has to be just one simple sentence. This Act is applicable when the owner, the sole owner, the builder, submits all the declarations for all the apartments. That's the only way how it can work. Because the moment the first apartment is sold, then it becomes uncontrollable situation. So before the first apartment is sold, it has to be made mandatory on the builder by this act that the builder has to file the declaration for all the units with the competent authority and complete the registration process. Then when the units are sold, it can be just made a statement in that saying that your apartment has been registered with the competent authority under the provisions of Kerala Apartment Ownership Act 1983. Simple. Don't wait for the all owners to assemble. It will never happen. It will never happen. Because practically we know that. Even forget about 572. Even getting 50 owners together willing to file this declaration is impossible. 50 people have different views. Why should I? Somebody will ask. So, to avoid all the complication, the amendment has to be made to section 2 regarding applicability of the law. Simple one sentence. Sole owner, the builder is mandated to complete the registration process by submitting declaration for each and every unit with the authority. Simple. The matter is closed. Then, second point is unnecessary connection. It is not mentioned clearly in the act, but like the RERA member did, it can be interpreted that your association membership is linked to your declaration submission. No need. The declaration submission, the act clearly says just to make sure that inheritable ownership to your property, not your association membership. Association is it's a body to be formed to manage the property. So association membership should be very clear, linked to a general body majority passing a bylaw as a common guidelines for managing the property and the conduct of the members. Nothing to do with your registration of the declarations. So this is the second point where the act has to be cleared, very clearly mentioned. The declaration of the submission of the declaration has no connection with associate membership. If you are an owner there, if you want to own a property, you are expected to be automatically a member of the association and subject to the bylaws adopted by the majority in the general body. So if we do get these two things clear, most of the problems related to this Apartment Ownership Act of 93 is solved. Then there will be minor corrections as when more people start adopting and practicing. That may come from practical experience. If these two changes are made, at least this law is doable. People can try using it. Now today what happens, like us, following us, any society or any apartment owners association who want to use this act, they are forced to go to the High Court. Everyone knows that they are following our footsteps. You people got the registration through a High Court intervention, so they are also going. So High Court will give you where whoever goes. Why should we have a system like that? There is an act passed by the legislature 40 years back. Why should everyone be, every would-be user be forced to go to the High Court to get a directive? Let's judicially use its powers to direct the government or whoever is responsible to clean up the act and make it usable. Also, according to that, there should be a competent authority clearly defined. Regulatory infrastructure, statutory infrastructure like separate section in the sub-registrar office to track this. And most importantly, there should be, as part of the judiciary intervention, a clear stoppage or clear directive to the Registrar General or whoever is the executive body to stop from immediate effect registration of Apartment Owners Association under Societies Act. We know it is a lie. No Apartment Ownership Act is an ownership association is a charitable society, not literary or scientific society. Why we are forcing or allowing them to register under the Societies Act? So judiciary should clearly give a direction. No, from today, no more registration of apartment owned associations registering under Societies Act. With this is the only way to first get the act cleaned up. Secondly, give clear instruction from tomorrow onwards, no more registration of apartment owners association under Societies Act. Then maybe another 2, 3, 4, 5 years, we'll have things stabilized. People start using this. Otherwise, there is no end to it. People using some excuse or other, even today, our complex, the senior advocates telling that you don't understand law. This is not law. You should go and register under the Societies Act. There are. So this is the only way to use clear instructions saying that nothing doing, this is the act. Use it. Otherwise, this drama will go on.
Okay.
Thank you. Thank you for listening, Mr. Sala.
Thank you, Mathew. Now, I think the organization suggests a short break and come back for further discussion so that we will be fresh. Now, all the three panelists have advocated for legislative change. Lawyers normally stand for judicial resolution of the dispute. Lawyers, as a lawyer, I would say, suppose the legislature refuses to do that, is our remedy in this MKD hall or on public street? I don't know. The only possibility is have a judicial resolution of the problem. We will discuss it after we come back after the short break. Please.
As President said, we have a tea break now, and after which we'll have open for discussion.